Welcome to everyone. A couple more folks still connecting to audio, but I think it's okay for us to go ahead and get started. And as folks join in, we might have the group grow a little bit in size. So for those of you who haven't had a chance to meet me yet, my name is Amelia Wald. I'm the Executive Director of the Virginia Club of New York. So I have the pleasure of introducing all of our wonderful faculty members that we get to interact with over the course of our virtual programming. I'm going to run through a couple of housekeeping tips for you all. So as you're aware, this is a meeting and not a webinar. So if you unmute your mic, there will be some background noise. So we just ask that you keep yourself muted throughout the course of the conversation, and then we'll open up Q&A right at the end. So in the meantime, you're welcome to put your questions in the chat function. Any questions you have, feel free to drop them in there throughout the presentation, and I'll go back at the end when Professor Duvei has finished her presentation, and we can go ahead and dive into the audience Q&A from then on. Depending on how many folks stay on the call, I may at some point invite some of you to unmute yourselves to ask your questions. If that's the case, please just mute yourself after you've finished asking your question. So with that, it's my pleasure to introduce Nomie Dave, who is a professor of music at UVA, as well as the director of the newly founded Sound Justice Lab, which we are very excited to learn more about. So I am going to turn the conversation over to her since she's the one you're here to see, and I'll pop back at the end for that audience Q&A.
Thank you so much, Amelia. Thank you very much to both you and Michael for this lovely invitation. And I'm really pleased to be here with you all. And I see one of my former students, Nadia Hara. So that makes it even more special. So thank you very much. I will just very quickly tell you a little bit about my own background before I get into the substance for today. So I, as Amelia said, I teach in the music department at UVA. But before this part of my career, I had a previous career as a lawyer. And so the work that I've been doing over the past let's say 3 or 4 years is very much at the intersections of law, anthropology, and music and sound studies. So building on my own various career paths. And in particular, I've been focusing both in the past and in the past few years on issues of gender justice. So as a lawyer, I worked on cases with individual cases of survivors of violence. I also did research on women and children, protection of women and children in conflict situations in West Africa. And then over the past few years, I've been doing research on feminist activism. And so I'm going to speak a little bit about that today towards the end of these remarks. So the focus of my remarks today are around this concept of amplified justice that's been at the center of my recent work. And I'm actually teaching a class on this subject next year. Nady, it's actually part of the civic engagement program that you were part of. So thank you for this opportunity again, because it helps me test drive some new ideas for that class. So besides teaching, Amplified Justice is also a project. It's a collaborative project that involves a couple of different research projects and some creative work and teaching, of course. And there's really 2 sister projects in it. One of them is a collaboration with 2 colleagues at UVA, Professor Ann Coughlin, who's a wonderful professor at the law school, and Professor Bonnie Gordon, who's my fantastic colleague in music. And we're at the very beginning, very early stages of a collaborative project on gender justice work in Charlottesville and at UVA in particular. And we're hoping to get students involved, both undergraduate and graduate students involved in that project. And in addition to that, as I said, there's a sister project, which is based on ongoing research that I've been doing in West Africa for many years now. And that's a collaboration both with a feminist collective in West Africa and with a fantastic PhD student in anthropology at UVA, Bremen Donovan. So I'm not going to really go into detail about these projects today because it's beyond the scope of my remarks, but I'm happy to give more information in the Q&A. But what I did want to talk about today is the idea of amplified justice more broadly, starting with some examples of sound in politics, then thinking more specifically about sound and listening in the law, and then thinking about what this concept of amplified justice means in this context. So I'm going to share my screen, and there'll be a little bit of back and forth because I have a bunch of different things that I would like to share with you all, but I'm going to share my screen to show you some slides. And I want to start by introducing 2 quotes The first quote is by the suffragette activist Emmeline Pankhurst, who in 1913 declared that, quote, "You have to make more noise than anyone else in order to affect political and social change." And then the second quote that I have is from 1948 by Supreme Court Justice Felix Frankfurter. And Frankfurter said in 1948, quote, "The men whose labors brought forth the Constitution of the United States had the street outside Independence Hall covered with earth so that their deliberations might not be disturbed by passing traffic. Our democracy presupposes the deliberative process as a condition of thought and of responsible choice by the electorate." So what Frankfurter is saying here is that sound, quite literally, had to be muffled outside of Independence Hall so that the drafters of the Constitution could do their work with sufficient peace and quietness. So here in these two different quotes, you see two very different ideas about sound and silence as preconditions for democracy. On the one hand, you have Pankhurst's quote in which she's saying that sound and noise are the necessary tools for democratic action. You have to make noise. And then on the other hand, you have Felix Frankfurter, who says that silence and quiet are the necessary conditions for democratic deliberation. And what really interests me about these two quotes is that while we often speak of politics in terms of metaphors of voice and silence, so for example, you've all heard these kinds of metaphors. We talk about giving voice to the voiceless or having one's voice heard, or alternatively, the idea that silence is violence. These very metaphorical ways of talking about voice and silence in politics. What's interesting here is that both Pankhurst and Frankfurter are not just speaking metaphorically here. They're actually talking about noise and silence as modes of political engagement. So I want to share a couple of different examples here to get us started by thinking about sound as political action. And one way that we can think about that is through voice. The ways in which voice conveys so much more than words and text alone. And here I have a picture of FDR from his fireside chats in the 1930s. And as you all know from this story, recording technology, radio broadcasts allowed FDR to broadcast his voice from the intimacy of his own home into other people's homes, the homes of ordinary citizens around the country. So this idea that his voice, the voice of the president, was made accessible, it was made familiar, it became intimate. And of course, it's also a way of humanizing the leader. And this, by the way, is a tactic that's used not just in democratic contexts, but also in authoritarian contexts. With similar techniques of broadcast. On the other hand, we can also think of examples of sound as weapon. So again, thinking of sound as action beyond metaphor. And so here I have a picture of a weapon that's called the LRAD. It's the long range acoustic device. And it was developed by the military as a means of using sound waves to assault the ears of bystanders as a means to disperse crowds. So it's been used very much in military interventions, in siege situations, et cetera, but it's also, as we see in this picture, been used by the police on the streets against everyday civilians. We have lots of other examples about sound as torture. For example, at the Abu Ghraib prison, the use of music being played at ear-splitting volumes and distortions as a way to really both assault the hearing mechanism of detainees, but also just to really break them down psychologically. So voice and sound, but we can also think of silence, the ways in which silence also operates in many ways as a mode of political action. So here I have an example of a silent protest. And you can imagine silent protest as a way to really refuse to participate on the terms given. And as I said, this is a protest by the NAACP in 1917. What's interesting is that there were thousands of people involved, 8,000 to 10,000 people apparently. And they have drums at the front, as you can see, but they muffled the sounds to make it all as quiet as possible. So it's this idea of kind of silence being deafening in a situation like this. We also, in our political culture, we also very much use the idea of silence as a form of reverence and reflection. So we have memorials in which individual and collective acts of moments of silence are meant to really draw on our are really meant to memorialize particular events. And of course, moments of silence, moments of quietness that are just built into everyday life. I'm just going to stop sharing for a minute now, just to mix things up. So these various examples all show us why sound matters to politics. Sound and listening are ways in which we make sense of the world, that we gain knowledge of the world, but they're also forms of action that can be shaped and adjusted according to our various goals. So with that brief introduction, let's think more specifically about sound and listening in the law. And I want to think about how legal proceedings play out through sound. What can we learn by listening closely to the law? And of course here, the concept of listening is fundamental, fundamental to the legal process. The term itself, hearing, as we know, hearings as a central mechanism in this process, the idea of a fair hearing. And this mechanism, this process, this mode builds on millennia of practices of rhetoric, of oratory, of persuasion through voice. So we know that legal proceedings, actually formal and informal legal proceedings are based on oral arguments delivered by both parties. And so this example just reminds us that the law is practiced in sound. It's dependent on listening. And here I want to mention the work of a legal scholar, James Parker, who's been really influential in pushing this, in opening up this conversation around sound in the law. And he wrote a book in 2015 that's called Acoustic Jurisprudence. I have a slide of it that I'll put up in a minute so you can see. And the book actually is an exploration of the International Criminal Tribunal in Rwanda and a criminal trial that they had against a Rwandan musician, Simon Bikindi, from 2006 to 2008, I think. But more broadly than that, he explores all sorts of practices of listening, use of sound technologies, and use of audio recordings in the courtroom to really think about these questions of sound, of the law always being implicated in sound. So I want to build on Parker's work by thinking of a couple of different contexts and examples here about both audibility in the courtroom in general, and then more specifically audio as evidence. So in popular representations, of course, I'm going to share my screen here. So bear with me for the back and forth as we kind of jump around between slides and different things like that. This is actually the book that I just mentioned, James Parker's book, in case anyone is interested. So like I said, thinking about audibility in the courtroom, in popular representations, we think of legal proceedings taking place in this quintessentially cinematic setting of the courtroom. And there's this whole genre of courtroom drama, as we know. Of course, so many cases are actually decided through out-of-court settlements, but that's far less exciting to our imagination. So not so many movies made about out-of-court settlements. But the courtroom is really imagined as this place of theater and performance, which of course it also is. So it's both a question of imagination and of its intent. The courtroom, because of this whole structure of drama and of theater and performance, courtrooms have a particular hold on our imaginations. And legal scholars have written about these questions, about the fact that legal proceedings follow particular scripts, the fact that particular people occupy roles and play certain characters. And of course, in any courtroom, there's a hierarchy that is signaled spatially. So of course we can see that here. This is just a still from To Kill a Mockingbird. For those of you that have seen it, many of you might recognize it already, but we can see that, the spatial hierarchy that plays out, obviously, but also we can think about how that hierarchy between the roles in the courtroom plays out sonically. Who has the right to speak and when? Who can interrupt? Who needs to sit silently and can only speak when they're called on? So of course, the performance here is greatly played out through voice. I want to share with you a historical example of this type of dynamic. And the example that I want to share with you is from the Rivonia trial in South Africa that was held from 1963 to 1964. And this, as many of you may know, was the trial in which Nelson Mandela and 9 other Black South African leaders were arrested. They were charged with sabotage and charged with fomenting violent revolution in South Africa. They were brought to trial, and many people believed that they faced the death penalty. And in 1964, in April 1964, so towards the end of at the end of the trial, Nelson Mandela himself, who was accused number 1, as you can see here, Mandela gave a 3-hour speech in his defense. It's one of the this is one of the most famous political trials of the 20th century, and his speech in particular is one of the most famous political speeches of the 20th century as well. And in the speech, he denounced the racism of apartheid. He explained the work of the ANC. He challenged the very notion of white supremacy. Now, this speech had a transcript that circulated around the world. And in particular, his powerful closing words here really helped to shift the tide of global outrage against the white South African government. But nonetheless, after his speech, he was found guilty. He wasn't sentenced to death, but he was sentenced to life imprisonment at Robben Island. And what I want to draw our attention to here is that in 2001, the British Library Sound Archive, a curator from them, from the British Library Sound Archive, was working with the National Archives of South Africa. And they realized that there were these recordings. They're called dictabelt recordings, which is really an obsolete recording technology, but there were these dictabelt recordings that had been made of the trial, and they had never been heard before because it was, after the trial, they were just packed away somewhere. So they'd never been made public. And because it was this obsolete technology, they had to spend a good amount of time recovering them and transferring the audio tapes and cleaning them up and really making them audible. And they were released in 2001 for the first time. So what I'm going to do is play, I'm going to play the audio here. And this is actually on a clip from the Guardian newspaper. And I really like this clip just because of the ways in which they've done the subtitles. But what I would like us to do is to listen to this clip. So again, you'll be relieved to know it's not the whole 3-hour trial, but it's the last 3 minutes of sorry, not the whole 3-hour speech, but the last 3 minutes of Mandela's speech. And what I'd like you to do is listen into what you hear in it in terms of his voice. So try to focus not on the visuals, but as much as possible on the sound of the voice, and think about what you hear in it. And I also want us to think about what hearing the recording adds to our knowledge and experience of the trial.
Our fight is against real and not imaginary hardships, or to use the language of the state prosecutor, so-called hardships. South Africa is the richest country in Africa and could be one of the richest countries in the world. But it is a land of extremes and remarkable contrasts. The whites enjoy what may well be the highest standard of living in the world, whilst Africans live in poverty and misery. Poverty goes hand in hand with malnutrition and disease. The incidence of malnutrition and deficiency diseases is very high amongst Africans. The incidence of infant mortality is one of the highest in the world. The lack of human dignity experienced by Africans is the direct result of the policy of white supremacy. white supremacy implies black inferiority. Legislation designed to preserve white supremacy entrenches this notion. I have dedicated my life to this struggle of the African people. I have fought against white domination, and I have fought against black domination. I have cherished the idea of a democratic and free society in which all persons will live together in harmony and with equal opportunities. It is an idea for which I hope to live for and to see realized. But my Lord, if it needs be, it is an ideal for which I am prepared to die.
So I'm actually going to put the link there in the chat so that you can all have the link, because it's really worth listening to the recording with headphones so that you can really make it out. And what's extraordinary, in this recording, it's hard to make it out, but what you can, if you listen closely, what you can hear at the very end of the recording is an audible gasp in the courtroom. And until the audio was released in 2001, nobody ever knew that happened. So we knew obviously that this was a speech that had been immortalized over the decades, quoted over and over and over again, but nobody ever knew the reaction in the courtroom on that day. So of course, to have access to that, to actually be able to hear that gasp adds a whole level of experience and interpretation to the events. We get a sense of being there, of history in the making. If we think about Mandela's voice itself, I'm thinking about the first question that I asked, what do we hear in it? We can hear, first of all, this very measured pace that he takes, this very deliberate rhythm and cadence that he has, in which he's creating a momentum with his voice. But he's also very strategically using pauses and silences. In particular, before he gets to that last devastating sentence in which he says, which he ends with the words, "For which I am prepared to die." He has a longer pause there. And so again, it's a very strategic use of silence to really build up emotion, to build up feeling. We also notice a shift in timbre. So for those of you that are unfamiliar with this word, it's a word that is used by music and sound people to describe the kind of most apparent characteristics of a sound. So sometimes referred to as tone color. And here we can hear, he starts with this, he has this very deliberate emphasis, this, we have seen, as I said, this kind of very, this very deliberate and sort of halted cadence. And a kind of hard staccato emphasis. And then he shifts his timbre when he starts speaking about himself and his own life. He switches to a softer, quieter timbre in which he's kind of reflecting back on his life. And then of course, there's that shift again on the very last two words where he says, "to die." And he says this, he raises the intensity right before he delivers those last two words. So the voice, the sound of the voice is enormously effective and significant here. It tells us something. And what this example shows us, as I said, in addition to the sense of the voice giving us a strong sense of the human being and the human struggle that's really at the heart of the story, bringing the moment to life, we also can hear the ways in which sound conveys meanings and feelings in ways that text cannot. So as I said, the transcript of this trial had circulated for decades, but there was something ineffable and extraordinary once the audio was released. We can hear all sorts of layers of meaning and feeling in the tone, in the timbre, in the pauses and silence, as I said. And we can hear his strategy, his voiced strategy, voicing as strategy. And so I think of an idea by the anthropologist John Comaroff, who speaks about the idea of lawfare, in other words, of using a legal context. In this case, a prosecution. It was Mandela himself who was being prosecuted. And yet he somehow turns it around. He uses this idea, he uses the court, he uses the witness stand as a means of fighting back. So, yeah, if you get a chance, listen to the recording, but listen to it with headphones on so you can get that gasp at the very end. Thinking about a much more recent example, we can also think of closer to home example of the significance or role of this question of voice and listening in the courtroom. And here I was thinking, as I was preparing for this, I was thinking about a decision by the US Supreme Court last year for the first time ever, to allow live audio streaming of oral arguments. And so as many of you may know, the Supreme Court has for a long time, so of course they released transcripts of their oral arguments, and they've also released audio recordings for a long time of sessions, but those were always after the sessions were concluded, even if it was same day audio. They'd never allowed live streaming or live broadcasting of audio. And so the question is, why does it matter? Why is it significant? And also, why did they resist this move for long? If you go to the Supreme Court website, you can find both the transcripts and the audio. And for sake of time, I'm not going to play any now. But we know that, again, thinking back to these ideas of democracy, we have this idea that audio creates transparency. If you can hear the voices of the justices, you get a sense of accessibility. This idea that we're able to be there, that it's more, we have a kind of more authentic experience. So it's connected, like I said, this whole idea of transparency that's really connected to our idea of democracy itself. Of course, we know that there's limits to this. We know that there's limits to our accessibility to our access to any judicial spaces. So we know that in the Supreme Court, for example, the judges deliberate privately in the conference room to discuss cases, and no one else is allowed. But I wanted to mention another example. I'm sure that many of you heard about this, the famous toilet flush of was it 2020 or was it earlier this year? But the fact that a sound of a toilet flushing was caught in an audio stream of Supreme Court oral argument sometime this year. Thank you very much, Stephanie Lake. And you can find the clip, again, for sake of time, I'm not going to play the clip, but you can find it all over the internet. And I feel like, this example of the great toilet flush of 2021 really sort of highlights the tension that I'm mentioning here. So on the one hand, we could say, yeah, in some ways, it's the ultimate humanizing, right? The ultimate transparency and accessibility, that we feel, these great venerable justices are actually no different biologically than us. But also it kind of highlights the tension there, the reasons why they don't want to give too much access, too much transparency. It's a threat to the dignity of the court, and leads to a lack of reverence. And so this, it shows us some of the tension there. So again, you can look that up in your free time. So in addition to, oh, sorry, thank you, Stephanie Lake, 2020, but within the last year. So in addition, I also wanted to just briefly mention the use of audio as evidence. And of course, we know that audio has been used as evidence for a very long time, but there's an increasing, alongside this increasing use that we have of cell phone videos admitted as evidence in court, we also have an increasing use of homemade audio recordings, particularly with just the easy access that we all have to recording devices. And it's interesting, I actually found some tips. I'm not going to show them for sake of time, but I found some tips on a law firm website about making recordings, making one's own audio recordings for divorce and family law cases. And what's interesting about that example is that they actually really give some kind of idea about technique. So for example, they say, don't laugh in the recordings, don't have children, don't make the recording too long. So they're thinking not just about recording as a fact, as a truth claim in itself, but also as a strategy, as a technique. So this idea of recordings as inherently truthful, as a kind of unassailable evidence. And then, of course, on the other side, we can think of innumerable concerns around audio surveillance, ancient practice or very old practices of eavesdropping to more recent practices of wiretapping, and concerns about breaches of privacy here. I actually read about concerns around recordings made from home audio devices, so these smart home devices being used as evidence in court. And apparently there was a criminal case in the US in 2017 in which a defendant was acquitted in a murder trial, partly on the basis of recordings from an Amazon Echo device. I'm just going to put the name of the book here again, which is Acoustic Jurisprudence. And the author is James Parker. So let's shift to questions of gender justice, struggles for gender justice, and think about how these dynamics of voice, sound, noise, listening, silence that I've been describing are present in these struggles for gender justice. And of course, we've thought about voice and silence and the ways in which they create dynamics in court proceedings more generally. But very specifically, there's innumerable examples of these dynamics being used in and shaping rape trials, for example. And many legal scholars have written about, legal scholars and sociologists and anthropologists have written about language and discourse in rape trials, for example. So for example, discursive practices in which survivors and witnesses are asked about their dress, or they're asked about their drinking habits, or they're called, the judge uses the word promiscuous, for example, in a South African case that I read about recently, to describe the witness. So all sorts of ways in which words and language can shape the trial, but we can also think about how voice and sound do this as well. And I have three points here that I want to make. The first is about vocal disciplining. The second is about the female voice is unreliable. And the third is vocal authority. And here, just to note, I'm speaking here a lot about the female voice because the research project that I'm doing in West Africa is very much focused on female voices, women's voices. But as I said, there's a sister project in Charlottesville and at UVA, and that's focused on marginalized voices more generally. So also thinking about queer voices, racialized voices, and these same stubborn practices of listening that shape all of them. But here I'm going to be speaking more about female voices. So first of all, thinking about vocal disciplining, we can listen into the ways, for example, in which a lawyer might manipulate silence in the courtroom in order to establish a witness's lack of credibility. So for example, letting the pause after a witness's statement hang a little too long in the air. Also, have practices of cutting off a witness or speaking over her as a form of control and domination. And so here I have a clip from you, which is not of a rape trial. It's actually not of a real trial at all. Forgive my sensationalized example, but it's actually from a soap opera. But I just thought that it was a kind of vivid example of some of the dynamics that I'm discussing here. So I'm not sure what the soap opera is. Maybe one of you can identify it for me. But what I want us to do is listen to this very, as I said, obviously very fictionalized, very sensationalized trial setting, but listen into the ways in which power relations play out through sound and play out through voice. So we'll just listen to this, or rather watch this quite quickly.
That he made mistakes. But the truth of the matter is your father was a deeply troubled man, wasn't he? For the days and the weeks, even the months before he was killed.
He could have gotten better, though.
So the answer is yes?
Yes.
Sorry, I can't hear you.
Yes.
Yes? Thank you. And so you say when your father could have gotten better. How is that? How would your father have been able to get better?
He could have had professional help.
Professional help. And that is something that you are very familiar with, isn't it? Needing and getting professional help, because you yourself have a history of mental disturbances, don't you, Lizzie?
Objection.
Well, that goes with the credibility of the witness.
Overruled.
Thank
Continue.
you. Lizzie, there was an incident involving your car, and you were driving and you hit a pedestrian, nearly killing him, but then you left the scene. Is that right?
I didn't know I had hit anyone. It was an accident.
Okay, there was another incident then where your then stepmother, Olivia Spencer, who was very pregnant at the time with your little sister Emma, she fell down a flight of stairs at the Beacon Hotel.
That was an accident, okay? I was standing right there. I watched the whole thing.
Then there was another incident.
Okay, I'll let you follow that gripping story in your own time, if we can figure out what the soap opera is. So like I said, obviously very dramatized, sensationalized depiction here, but interestingly, we see a sort of exaggerated version here of dynamics around voice and control and disciplining that many legal scholars and sociologists, or a number of them, have written about. So, for example, some of these tactics are quite familiar. Thank you very much, Guiding Light. So, for example, at the beginning, he asks the witness to repeat herself because he can't hear her, and so she does, but she speaks a little bit too loudly. At another point, he's asking questions, and you can hear her voice kind of conveying this emotion, sort of breaking, faltering, hesitating. And then, of course, her again kind of getting louder as he's pushing her and cutting her off. So again, thinking about the ways in which these techniques can be used as forms of disciplining. The second point that I wanted to make here in regard to voice and silence in this context is around longstanding ways of hearing the female voice as unreliable, as lacking credibility, and signaling naivete. And again, of course, these 3 points are all overlapping. And here I'm thinking about the historian and classicist Mary Beard, who writes in her book, Women in Power, that for millennia, quote, public speech was if not the defining attribute of maleness. In other words, that men obviously controlled that public discourse was obviously male dominated, but that the act of it itself was a sign of and a kind of exercise in masculinity. And so as a result, as Beard points out, the female voice has been continually belittled and dehumanized across millennia and in a wide range of geographical and cultural contexts as a means of silencing women. And so in my own research in West Africa, this is one of the areas that I'm looking into, are kind of some of these longstanding ways of hearing. Sound studies scholars refer to this as the public listening ear. What is the public listening ear in a particular place or time? And one example that I think of, and I often teach about in my classes at UVA, is around contemporary, involves a contemporary Euro-American habit of particularly criticizing young women's voices. For vocal practices such as vocal fry or uptalk, for example. And so for those of you that don't know, vocal fry is a technique that you've all heard, but maybe aren't able to identify by the term, but it's basically a lowering of the pitch. So then syllables sound kind of frayed, and then they're drawn out to really bring emphasis to that. So for example, talking like that. So so very much kind of a prevalent speech pattern that we hear oftentimes in Euro-American society, and one that's very much associated with young women. Uptalk is the upward inflections at the end of a sentence, so that you sound like you're asking a question. And so we've all heard these ways of speaking be ridiculed, and we've probably partaken at different times in some of that ridicule and satire. But what I want to draw our attention to is the fact that these ways of speaking are really seen as evidence of young women's lack of seriousness, of their frivolity, of their lack of intelligence, and that this kind of constant criticism about the ways in which young women in particular speak is a form of policing that we hear, that we hear in our own society. Just to note, by the way, that there's been research that shows that that young women are actually innovators in many of these vocal patterns, that these patterns often start with young women and then migrate to the rest of the population. So there have been recordings of congressmen, for example, speaking with vocal fry, or of people in all sorts of walks of society using uptalk. So rather than criticizing and policing young women, we can reframe it and think about the ways in which young women are really innovators here in kind of pioneering these ways of speaking. And so this point brings me to the last point that I want to make here, which is around vocal authority. As we know, female voices are often heard as unauthoritative, and this is particularly true in political contexts, and particularly around the question of pitch. So we have a very familiar critique of female politicians' voices as being, or female authority figures' voices as being too thin, too shrill, too whiny, too high-pitched. And I want to play an example of Margaret Thatcher's voice here to show you this dynamic. So Margaret Thatcher, the former Prime Minister of the UK, and of course, as we all know, we think of her from her 1980s image as the Iron Lady. So she was very masculine, she was very gruff, she was very square with her big shoulder pads, she was very tough. She exuded power, and she had this voice to really manifest that power. And what was subsequently found out was that she, or actually maybe what people knew all along, was that she spoke very differently in the early part of her career. And then she undertook vocal training. She undertook coaching to lower the pitch of her voice. So I'll just play a quick clip for you so you can hear this first clip, which I think is in the late 60s, early 70s, and then a later one, which is the kind of iconic Margaret Thatcher voice, Maggie Thatcher voice that we know.
I've been so busy that I haven't had really much time to think about it. After all, I know I'm still only me, and so do my family. But I'm very much aware of the responsibilities and a little bit apprehensive. Who wouldn't be when you think of the names that I follow?
Let me answer that very deeply, because I feel very strongly about it. The greatest divisions this nation has ever seen were the conflicts of trade unions towards the end of a Labour government.
I've been so busy.
So, of course here I should state once again that my intent in showing this clip is not at all to criticize Margaret Thatcher or to police her voice. Sorry, just cleaning up my screen here. But for us to understand the dynamics at play and also the pressure that she was under. And there's a lot of research actually shows that there are very strong correlates between pitch, vocal pitch, and ideas of authority. So a number of studies which have shown that we tend to hear people with lower pitch voices as more authoritative. And of course, there's nothing kind of biologically inherent about this. This is all constructed. So I want to shift in the last few minutes to connect these ideas to the work that I'm doing around the female voice and ways of listening. And I'm just going to mention my current research project around the use of voice in feminist activism. And as I said, I'm working on two sister projects, one in Charlottesville and at UVA, and another one in West Africa. I'm happy to talk about the Charlottesville one in the Q&A, but I'll just talk about the West Africa one for now. It centers around, it's a research project, a collaborative film project. I see my colleague Kevin Everson here, who has been a really fantastic interlocutor and source of inspiration on this in this conversation, in this kind of emerging work so far. Artist and filmmaker himself, or I'm sure that all of you know him already. But anyway, so the project centers, the project in West Africa centers around a recent defamation suit that was brought against a West African journalist. Her name is Musa Yoruba, and I'll just put her name in the chat. I had a slide, but I will, for sake of time, I'm not going to go back and forth again. So she's a West African journalist, and in 2018, she reported on a sexual assault case. She didn't name any names. She spoke in quite general and careful terms, but she spoke about it on her radio program, and the alleged perpetrator, again, as I said, he was never named over the airwaves, but he sued her for defamation, and he subsequently won the case. And so the project that I'm working on with Berman Donovan, who I mentioned, a PhD student at UVA, as well as our Ghanaian collaborators, is telling the story around this defamation suit and its afterlife. And we're telling the story from different perspectives through a series of different shorts to really explore questions of sound, listening, and voice in defamation cases. So in part, it's a story of voice and ways of hearing, in which journalists and activists challenge these pernicious ideas about the politics of the female voice that I mentioned, and this question of vocal authority, who has and doesn't have it. And I think I might just have time to share a quick clip with you. So let me see if I can quickly do that. Amelia, do I have about 5 minutes or so left? Yeah, okay, thank you. So in that case, I'm going to go back to my slides here. This is actually the journalist, Musa Yaruba, that you can see. This is at the first hearing in September 2018 in the defamation suit against her. And I want to play a clip. So what happened was she was found guilty of defamation in January 2019. And within a couple of days, a feminist activist collective called a press conference after the verdict was rendered. And what I want to do is to show a couple of really brief clips from this press conference to draw our attention to the ways in which the activists are trying to use their voices to claim the sound space here. So let's listen first at the very beginning. So this is at the very beginning of the press conference. Like I said, these are young feminist activists. They've come to speak out against this, the verdict against this journalist within the context of this larger sexual assault case. And what I want you to do is just listen in here to what happens to their voices. This is at the very beginning.
Avant la lecture de la déclaration, à vous la parole.
Dénoncer n'est pas un viol. Dénonçant n'est pas un crime. Dénoncer n'est pas un crime. Dénonçant le viol. Dénoncer n'est pas un crime. Dénoncer n'est pas un crime. Dénonçant le viol. Dénoncer n'est pas un crime. Le violeur est un criminel. Le viol est un crime. Dénoncer n'est pas un crime. Dénonçant le viol. Dénoncer n'est pas un crime. Le viol est un crime. Le violeur est un criminel.
So what we hear in this clip is the activists mumbling and faltering. We hear their pauses, their hesitation, the downward cadences of their responses, the quietness of some of their responses. At one point, you can hear the timbre of male voices in the audience that are taking up the vocal part louder than the activists themselves. So that was at the very beginning of the press conference. And now I want to play another really short clip from you. And this is at the end of the press conference. And what happens at this point is that the activists have delivered their statements. They had a prepared declaration and they delivered that. And now, once again, they're trying to use their voices to really seize the energy in the room.
Je vous remercie. Répétez tout simplement cette phrase. Dénoncer n'est pas un crime. Dénoncer n'est pas un crime. Dénonçons le viol. Dénonçons le viol. Dénoncer n'est pas diffamer. Dénoncer n'est pas diffamer. Le violeur est un criminel. Le violeur est un criminel. Et le viol est un crime. Le viol est un crime. Dénoncer n'est pas un crime. Dénoncer n'est pas un crime. Dénonçons le viol. Dénonçons le viol. Le viol est un crime. Le viol est un crime. Nous activistes, nous devons être protégés. Nous activistes, nous devons être protégés. Dénoncer n'est pas un crime. Dénoncer n'est pas un crime. Dénoncer n'est pas une diffamation. Dénoncer n'est pas une diffamation. Abat le viol. Abat le viol. Abat les violences. Abat les violences. Merci.
So what we hear in this second clip is a switch of technique. So in the first part, they're using this call and response. In the second clip, we hear that they switch to a human microphone technique, which is where one person says the line and the rest of the room calls it back. And the switching of techniques allows their voices to blend and to gain volume and intensity. And so we have unison chants here that really allow them to mobilize what we can think of as an audibility politics, to challenge the listening ear, this term that I just mentioned a little while ago. In other words, these ways of hearing, these longstanding ways of hearing, in a very male-dominated discourse and context, as well as a means to create coalition and solidarity for the activists themselves. So we can hear this power in their in the loudness of their vocalizations, but we also hear an improvisation, we hear variation, shifts in the timbre, shifts in dynamics. So in other words, from loud to quiet, shifts in the rhythm. And really what I hear this is a certain amount of pleasure that is happening through this variation, through this improvisation. And it brings in mind an idea that Adrienne Marie Brown has written about in her book, Pleasure Activism, which was published in 2019. And here in the book, she's talking about the ways in which social movements are need to be underpinned by feeling and by participants' sense of pleasure itself, as she calls it, a pleasure to be with each other. And so this idea is really important to me in terms of hearing the activist voices, activists amplifying their voices here to project their claims, but also to create this feeling of purpose and solidarity among themselves. So I just want to conclude by coming back to this idea of amplified justice and thinking both about amplification and about justice. Sorry if my phone starts. Maybe not. Okay, so amplification obviously refers to techniques of increasing sound, but we can think not just of loudness and vibration, but also transformations from one to multiple voices, which is what we hear in this last clip. What happens when a case is no longer about one individual survivor, but becomes a collective call? What happens when a voice or a story spills out of the courtroom and is heard and listened to more publicly in everyday life? What are some of the ways in which voices are amplified through radio, through television, social media, through microphones that challenge these patriarchal ways of listening that I've mentioned? And how can an amplified voice create danger, for example, a journalist being sued for defamation, but also create solidarity and collectivity? And so we can think about how amplification relates to justice. And here in my collaborations, my collaborators and I have been really grappling with this question of justice. What is it? What does it mean? What does it sound like? And one of the ideas that we keep returning to is this idea that the law, there's something about the law that is attuned to the past, that the law is about adjudicating past offenses and past violations, whereas perhaps we can think of justice as future-oriented, as fueled by aspiration, as pointing to better possibilities ahead. So, if we take this idea, we can think of justice not as an endpoint, but as a continual struggle for a better future. And so thinking this way, we can tune into these techniques of sound and amplification, these strategies of voicing that I've mentioned, these ways of challenging practices of listening, all as part of an ongoing process of testing out and shaping justice claims. So this is still very much an idea that my collaborators and I are working on, but you can imagine, if we think of this idea, you can imagine justice not as the sound of the gavel at the end of a trial, but the sound of the press conference afterwards, amplified out well beyond the courtroom and thinking already ahead to next steps. Thank you very much.
Nomi, thank you so much for that conversation. That was very, very insightful and compelling and really, really wonderful. So thank you very, very much for that. We do have some time for audience Q&A. So if you have questions, feel free to put those in the chat. We also have some questions that were submitted beforehand. So I'll go ahead and pull those up and then we can go ahead and get started with those questions first. So one of our questions is from a gentleman named Andrew, and he asks you, how have apps like Periscope or TikTok or Clubhouse affected the conversations within and without the justice system itself?
Okay, first of all, I'm 20 years too old to talk about any of that stuff, so I defer fully to you all young people. But I mean, we have innumerable examples of this blending or this blurring, and all of these questions around evidence, and also questions around speech. The Supreme Court case about the cheerleader who said, I can't remember what it was, on what, Snapchat something, and so this question of what constitutes public speech is obviously really the space of contention around some of these social media apps at the moment. So yeah, I guess we have to wait to find out what the Supreme Court decides about that, as well as what you all have to say, being closer to the ground in that respect than me.
Wonderful. Well, I mean, to your point, right, justice is future looking, so we still have a lot to learn and a lot to look forward to. Another one of our audience members whose name is I believe Karen, asks, what motivated your interest in transitioning from the legal profession to music studies?
Thanks. Yeah. So I was working in international law. I was actually working for the United Nations for 5 years. And, essentially I got very disillusioned with the work that I was doing in West Africa. And I also increasingly came to see that the work required a really holistic approach, focusing on human beings rather than just focusing on the status determination of an individual, whether they're a refugee or not. So it was that, and I am always very careful to kind of temper that my cynicism here. I met many extraordinarily humanitarian individuals in that context. So this is not at all a kind of blanket condemnation of that world. Anyway, but yeah, so I shifted away from law into anthropology because I was really interested. I'd been living in West Africa for 3 years. I was working as a lawyer, but I felt that I knew nothing about the people and the context and the place that I'd been living in. So I shifted to anthropology, and then that took me into music because in my research, the two are very closely connected, really as a way to understand everyday experience, everyday subjectivities, what it feels like, what it sounds like to be a particular person in a particular place. But, as I said, for the last 3 years or so, I've really come back to the law, and I miss the law in many ways. I miss its precision, I miss its tools. And so the work that I'm trying to do now is kind of trying to claim back some of my lawyerness. Like I said, I'm collaborating with Professor Ann Coughlin at the law school, which has been such a privilege. So, I think some of the most electric work and conversations can come really at these kind of points of interaction and meeting.
Wonderful. Thank you for sharing that little bit about yourself. And then we have another question, which I think is very pertinent. A lot of your talk obviously references your research, which is mostly based in Africa, but one of our audience members wonders if you have any suggestions for resources about acoustics around race and white supremacist institutions within the US.
Yes, absolutely. So so the first book that comes to mind is Jennifer Lynn Stover's The Sonic Color Line, which I'm going to put in the chat, which is really fantastic. I mean, she's actually, I just realized that I didn't reference her, but she's the author who I got this idea, that term, the listening ear, the public listening ear from. And it's a really extraordinary book around these same questions of ways of listening, but particularly about race and white supremacy in the US. And there are many more. So I will also put my email address here, and whoever asked the question, probably best if we communicate by email, and I can send many other examples, as well as colleagues of mine, both at UVA and at other places that are doing really fantastic work around those questions.
Wonderful. Well, thank you for offering to share even additional resources. And I'm also happy to send those out to audience members after the fact as well. So if you want to send those to me, happy to forward those to the rest of the group here. And then if you'll allow, I know we're approaching one last minute, but I wondered if I could ask a question myself, which is I'm very curious how you are envisioning implementing these lessons and these conversations in the classroom and really engaging your students in this dialogue. Would love to know what your plan for the class is.
Thank you. Yeah, that's lovely. So as I said, and I mentioned my student, Nady Hera, who is here. Hopefully, Nady, you're still here. So Nady was a student in a course that I teach through the college's Civic and Community Engagement Program, which some of you might not have heard of because it's fairly new in the College of Arts and Sciences. But it's really fantastic because it allows faculty to teach year-long classes, and it's explicitly designed to get students out of the classroom and to be connecting with community partners in Charlottesville or other places. And so this Amplified Justice class will be part of that program. I'm co-teaching it with my fantastic colleague, Bonnie Gordon. And we have lots of different ideas about the ways in which the class will unfold, including doing a day trip to Washington, DC to really think about to be in some of these spaces of reverential silence that I mentioned, and to sort of explore the acoustic properties of those spaces, going to the courthouse in Charlottesville and listening into proceedings there and thinking about how questions around gender justice and racial justice are really audible through proceedings. Also connecting with different community partners in the public interest law community in Charlottesville. So I've been in touch with a couple of people already, but you know, working on that over the summer. So we're very much planning to get students out of the classroom, as well as spending time in the classroom, really, really focusing on close listening, on histories of listening and their connections with gender and racial justice, and this, you know, this interdisciplinary conversation around sound in the law more generally.
Wonderful. Well, thank you so much. We are excited to hear how your class goes. I'm sure it will be a fantastic, transformative experience for your students and hopefully you and your community partners as well. So thank you, Nomi, so much for your time, for your expertise, for your engagement. I had a wonderful, wonderful time. It sounds like based on the chat, all the folks on the call agree. So thank you very, very much. And thank you to all of our audience members as well for being such wonderful and active participants.
Thank you. Thank you so much. Thanks for having me.